Hi, welcome to Constitutional Chats, hosted by me, Janine Turner,
and Cathy Gillespie,
with students
Vicarious
and me, Tova Kaplan.
Join us as we discuss hot topic issues with constitutional experts. It's sponsored by Constituting America.
Constitutional Chats. My name is Janine Turner. I'm the founder of Constituting America and the co-president. Come on in. We have a great topic for you today. It's the Fourth Amendment, the Bill of Rights, and you, with our special guest, Mr. Cully Stimson. Dakari Chapman, you see there. He's not with us today because he's on set. Tova Kaplan, extraordinary 16-year-old winner of our contest, and the president of our national youth. She's our National Youth Director and President of our National Youth Board. And Cathy Gillespie, Co-President of Constituting America. And she is also been chosen, one of the few 16 citizens chosen to be on the Semiquincentennial Committee. So we are thrilled to be with you today. And I'm going to toss it to Cathy, who's going to talk about our fabulous sponsor, Mr. Charlie Colvin. Cathy, you're on.
Well, thank you, Janine. And we do want to thank our sponsor, Mr. Charlie Colvin. This is the second time he sponsored a constitutional chat. And Charlie, we're so grateful.
We're going to talk now about the Fourth Amendment. Are you ready, everybody? The Bill of Rights and you. It's our series. We're doing all of Bill of Rights. We love doing series now. The Fourth Amendment. Briefly, Elisa Williams is with us too, who's our extraordinary editor and a director of media. But now I'm going to talk about our special guest, Charles Cully Stimson. Cully Stimson is a senior legal fellow and manager of the National Security Law Program at the Heritage Foundation. He is a third-generation naval officer, continues to serve as a Navy JAG, and is a captain. He is a former Deputy Assistant Secretary of Defense for Detainee Affairs. We can have long conversations about that. Accomplished trial lawyer and a prosecutor at the local, state, and federal levels, and is a former adjunct professor of law at the George Mason School of Law and a former high school teacher. So what a perfect guest to speak with us today about the Fourth Amendment, which is about, in a way, our security within our own home.
Thank you very much, Cathy. Lisa, thanks for having me. Tova, it's nice to see you. I've been asked to spend some time talking to you about the Fourth Amendment. The Fourth Amendment is one of those amendments that really lends itself towards one of those, well, how does it affect me? And I wonder if, and you can play 100 questions about whether it applies in this circumstance or this circumstance. So what I thought I would do, since I loved being a high school teacher, and I think this is the audience that has the biggest absorption rate compared to college and law school students that I've taught, is to start with some definitions. There's really two clauses to the Fourth Amendment. It's one long sentence, but it says the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, comma, but I want you to think of that as the first part of it, the first clause. And no warrants shall issue but upon probable cause. And we're going to talk about that because that's important to understand. Supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. So that's what your Fourth Amendment says. And so I have some 3 points I really want to make with you today. But let me stop there and just tell you what the 3 points are. And then Janine, if you want to jump in, you go right ahead. First, I think it's important for us to understand the history of it. Why? Why do we have a Fourth Amendment? What was it about the previous regime that required the Fourth Amendment to come into being in 1791 when the first 10 amendments came into being? Secondly, what does it cover? There's a lot of misunderstanding about what it might cover and what it might not cover, who it is applied against and who not, and then how has it been interpreted by the courts? And I think that's the one where most people jump to or start with how it's been interpreted. But before we even do that, you have to understand the key terms in the actual Fourth Amendment. So let's throw probable cause up on the screen so you can see that. Because you notice that in the Fourth Amendment, it talks about, in the second clause, probable cause. Probable cause is defined, as you can see on the screen, by more than a bare suspicion, but less than evidence that would justify a conviction. So for example, let me give you a real world example. So let's say your mom cooked a dozen cookies after school, and she said, don't eat any before dinner. And you're the only kid in the house. Your brothers and sisters are gone, and your dad's not there, and the dog is in the kennel. And before dinner, she notices that there's 6 cookies gone. Your mom is allergic to the cookies she cooked. She will have probable cause to believe that you ate those cookies, and she is reasonable. It is reasonable for her to suggest that you ate those cookies. So for Fourth Amendment purposes, there would be probable cause to believe that you're the one that ate those cookies. Let's turn to reasonable suspicion. This is a lower standard, and we're going to talk about that in the application of the cases. The reasonable suspicion standard, as you can see, was first enunciated in a case called Terry against Ohio back in 1968. You hear of things like a Terry stop. You'll hear that sort of in the vernacular, but Terry stop. That's if a police officer, based on his training and experience, he has reason to believe that an individual is engaged in criminal activity, then he has reasonable suspicion to temporarily detain you and perhaps even pat you down, what's called a Terry stop. So let's say a police officer is rolling up on a high drug area and he sees one person handing money to another, and the person receiving the money has his cupped hand and he's putting something in the money giver's hand. Well, there's reasonable suspicion to believe that a drug transaction may have been occurring. And so it would be reasonable under the Fourth Amendment for that police officer to detain both of them, pat them down, and see if that indeed is true. It's not a long detention, but it's a quick, brief detention. So now that you understand those general principles, at least definitions, I want to go a little bit into the history. But Janine, do you want to jump in here, or you want me just to go into the history?
Go ahead, please. Very fascinating.
So you all know from previous segments, which are really outstanding, in the Declaration of Independence, there were, it's essentially a complaint of wrongs, right? It's the king did this, the king did that, we tried to be reasonable, and he did this, 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 and this. Well, one of the things that led to the Fourth Amendment is the widespread recognition in the colonies of the right against unreasonable searches and seizures, because there were unreasonable searches and seizures happening all the time. Even though so you've heard from experts on the First Amendment and the Second Amendment and the Third Amendment, but you understand that these amendments were a direct reaction to the abuses by the king and a way to preserve specific rights of the people, us, against their new government. Historically speaking, several of the state constitutions adopted protections soon after the Declaration of Independence was proclaimed. So, for example, in 1780, the Constitution of Massachusetts announced that every individual had the right, quote, to be secure from all unreasonable searches and seizures of his person, his house, his papers, and all his possessions, unquote. That sounds familiar, right? The most significant abuse that had led to the adoption of the Fourth Amendment were two things: the execution of general warrants and writs of assistance. So a general warrant, which we don't have, were court orders authorizing government officials to search and seize evidence with few, if any, limitations on where the officials could search or what they could seize. Essentially, the general warrant would say, you can search Janine Turner's house. That's it. That's a general warrant. That's not specific. It doesn't talk about what they're looking for. And then a writ of assistance. The colonists were really opposed to writs of assistance because, remember the Boston Tea Party? It permitted custom agents to search any place in which smuggled goods might be concealed, even if there was no particular suspicion the goods were even there in the first place. Now, the Fourth Amendment, frankly, was dormant until the 20th century for three reasons. One, it only applied to the federal government. Two, the concept of modern police officers hired by the government to investigate crime didn't emerge until the middle of the 19th century. And three were the remedies piece. A violation of the Fourth Amendment remained uncertain until the introduction of what's called the Exclusionary Rule, which we'll talk about in a case called Weeks against the United States back in 1914, which meant that if it was unlawfully seized, it couldn't be introduced by the prosecution to evidence. Now, today, I can tell you as a former trial judge and defense attorney and prosecutor, the Fourth Amendment issues come up in lots of cases all the time. Now, last piece of history that you need to understand. The Fourth Amendment and the Exclusionary Rule applies to state and local police officers now because it's been incorporated to the states through the 14th Amendment. And I know you've heard about the incorporation doctrine, which means that this particular amendment flows up through the 14th Amendment and then applies to the states and state and local officers. And so that's the history. Now I can tell you about what it covers, and I have some good news and I got some bad news for you. First, the bad news. First off, your parents and your grandparents and your brothers and sisters and your friends, they can violate your Fourth Amendment rights. They can rifle through your backpack, your bedroom, your closet, your secret little diary, whatever it is your texts, and that's not a Fourth Amendment violation. That's disturbing. It's going to make you mad. Maybe you can sue them for money damages. Good luck with that. That's not going to happen. But they're not government actors, right? They don't work for the government. They don't work on behalf of the government. And so the Fourth Amendment protects you, the individual, against government action. So your parents, your siblings, they're not government actors. So the Fourth Amendment doesn't apply. But here's the good news. If a government actor searches you or seizes something of yours, then there's a two-step process that judges like myself would go through and ask two questions. One, whether a government search or seizure has actually occurred. And two, was it reasonable? And remember back from the original definition that Lisa put up there, it has to be reasonable, right? So let's talk about seizure, because I know a lot of your questions are going to stem around, was this lawful or was this not lawful? And you got to understand the definitions, and then it'll help you decide whether it's lawful or not under the Fourth Amendment. A person's property is seized when the government meaningfully interferes with a person's possessory interest in their property. And that occurs when the government takes a suspect's property away, or when the government forces a person out of their home, or when the government takes a package or letter out of the course of its delivery. A person is seized under the Fourth Amendment when the government terminates or restrains your freedom of movement, like when a government official places a suspect under arrest or temporarily detains a person, when a reasonable person would not feel free to leave and end the encounter. Now, a search is different. This is the one where we get most of the Supreme Court cases today, because the seizure is pretty clear. There's two tests for a search, and these are going to sound pretty familiar to you, I think. First, the government conduct is a search if it trespasses onto a person, his house, his papers, or his effects with intent to obtain information. That was reaffirmed in a case recently back in 2012, a case called United States against Jones. And second, the government conduct is a search if one, it violates the subjective expectation of privacy, and two, society is prepared to recognize that expectation as objectively reasonable. And this came from a two-part test announced in a case called Katz in a concurring opinion many years ago. So for the most part, government conduct usually ends up being labeled a search if it's an invasion into a private space like a home or a car or a package or a letter or a person's pockets. Then the last question is, was it reasonable? So if it's reasonable, there's no Fourth Amendment violation. If it's not reasonable, there is a Fourth Amendment violation. For example, let me give you one. A person can be searched without a warrant incident to his arrest. That means at this time of or subsequent right after the arrest, but absent any exigent circumstances, emergency type circumstances, a warrant is required to search the digital contents of an arrestee's phone. So let's say you're pulled over because you were stealing gum from the CVS, and the police officer saw you do that. And so they arrest you for stealing gum from CVS. They can't then, when they pat you down and find your phone, they can't get into your phone. They need a warrant to get into the contents of your phone. And some of you may have been following some of the cases where they were trying to get Apple to help break into phones for some certain shooting cases. Well, they needed a warrant to get into that. Let's say you're driving your car, and some of you, I'm sure, are driving age, and you get pulled over for speeding, and the officer sees an open beer can in your cup holder, and he suspects that you've been drinking and driving. So he performs field sobriety tests. He arrests you for drunk driving. He can pat you down. He can search your person, incident to arrest, your pockets, et cetera. And they can even do an inventory search of your car. But again, they can't search the contents of your cell phone. And there's an open question as whether they can get into the trunk or the glove box without a warrant. And most judges would say you need a warrant. So I can go into some other examples like home searches or consents. But homes are different. Cars are mobile. And the reason the court has ruled the way they ruled about cars is because they can move. You can get them out of plain sight. You can move to another state, another county. Homes don't move. And so the rules for searching homes tend to be much more restrictive than the rules for seizing and searching individuals. So in the case of a home, entrance is constitutionally reasonable. That means it's legal, only pursuant to a valid warrant or an exception to the warrant requirement. And remember, in our definition, that warrant, right, has to be specific. Because remember the problem we had with general warrants? I authorize you to search Janine Turner's house. Well, that's no good. That's a general warrant. The warrant has to have probable cause. We know what that definition is. And has to be supported by somebody swearing to tell the truth under oath and describe specifically what it is you want to search. Now, there's exceptions to the warrant requirement, like, for example, the exigent circumstances or consent by a party. So let me give you a consent example. Let's say a police officer shows up at a house because of a noise complaint by a neighbor, and an adult female opens the door, and he asks her if he can come in, and she says, sure. The police officer sees illegal drugs or weapons, like a machine gun, which is illegal, on the coffee table. That evidence can be seized without a warrant because it falls not only under the consent side, because she was able to give consent, but also because it's in plain views, and that's an exception to the warrant requirement. That comes from a case out of California called Horton against California in 1990. Let me give you the exigent circumstances. Exigent is a good SAT word, by the way.
Please explain that word, and then we'll go and just finish this up.
Exigent means emergency. All right. You don't have time to think about it. You don't have time to rub your chin and think long and deep about it. It's just a moment thing. It's got to happen quickly. So let's say a house is on fire, and the police officer is nearby, and there's one fireman on the scene, and he's got a little garden hose, and he's waiting for the other fireman to come with the real hose. And the fireman's like, "Look, there's a little boy in that house. I can't go in and get him. Can you?" And the police officer, "Oh yeah." So the police officer runs into the house to save the little boy, and while he's rescuing the boy, he finds an illegal machine gun or illegal drugs in the house. That evidence can be admitted into a trial against the person who owned the house or who was the owner of the illegal machine gun or drugs, because it was found under exigent circumstances. The cop was there for a totally different reason. It was an emergency reason. He didn't need a warrant to go save the little boy. And so he happened to see the drugs or the gun. Now, let me tell you the good news and bad news about cars, guys, especially you folks who just got your new driver's license or your learner's permit. And Tova, that's almost you, right? I mean, you're almost there. You're getting real close. The good news for you, Tova, is that you have a Fourth Amendment right when you get into your car. So you should be happy about that. The bad news is the rules for searching and seizing cars tend to give the government significantly broader powers than the rules for homes because, like I said, cars move. So a police officer can order a driver to pull over a car. They can seize your car and occupants based on any traffic violation. That's a 1996 case called Wren against the United States. The officer can arrest the driver based only on a minor violation, even if the crime of arrest doesn't even provide for jail time. I know that bothers some people, but that's what the Supreme Court held in 2001. Once the person has been arrested, he can be searched instant to arrest if the arrest violates state law, which I mentioned. And the car can be searched without a warrant if there's probable cause to believe that contraband or evidence is located inside the car. That's Carroll against the United States, a 1925 case, which hasn't been overturned. By the way, there's a recent case, and I used to try a bunch of drunk driving cases when I was a prosecutor. And one of the things when you try drunk driving cases is you want to get the blood alcohol level of the suspected drunk driver, right? You either use the breathalyzer that you blow into at the scene, or you take the blood, which is much more accurate than the breathalyzer. But a recent Supreme Court case held that the police could take the blood from a driver who was passed out in his car. In other words, he's incapable of giving consent. And he was suspected of drunk driving so that the police could check his blood alcohol level, even without a warrant. Why? Because the alcohol content of your blood dissipates, gets lower and lower and lower very quickly over time. You lose 0.02% blood alcohol content per hour. And so no warrant was needed, and they could take that involuntarily from a person incapable of giving consent. So that's
I was step in here. I would wait. Could they could get blood from the passed out driver, or how do they do that?
They get a phlebotomist.
Police officers have ready needles to draw blood.
No,
they need
no. Thank goodness.
So how does that work?
So in this particular jurisdiction, they had a phlebotomist, a person who is an expert in drawing blood, a nurse practitioner type person, worked for the police department, and they came on the scene and they withdrew the blood.
So they called backup.
Yep, that's exactly right.
All right, let me step in here to kind of unpack all this, because this is a phenomenal amount of information, and it's just terrific. And I have so many questions as you're going along. So yeah. All right. Let's just quickly, this is out of order, but the husband and the wife said, come on in.
Yep.
Wasn't there something at some point where the husband didn't consent? Like, what if the husband actually owns the house and the wife doesn't own the house at all? And if the husband walks up to the door and says, well, she may have let you in, but this is my house and I don't let you in. Wasn't there something in the news about that recently?
Yeah, well, there was more than something in the news. You're dead on. It's a Supreme Court case. And the issue is not whether you are on the title. You know, my wife and I, we own a house here in the Mid-Atlantic, and, we're both on the title. But the cops don't need to know that, nor does it matter for Fourth Amendment purposes. What matters is whether or not the person can lawfully give consent. And you don't have to be on the title. You actually don't even have to be married. So if an adult, let's say Cathy and I are hanging out at her apartment or her place of work, or she and I are over at a friend's house. Let's say we're over at a friend's house, and we've been there for 2 days because we're working on a big project. And the friend, Cathy and I, of course, are clean as driven snow, but the friend is into sketchy stuff. Let's say they're into stealing hubcaps. And the cops figured out that the friend is the hubcap stealer. So they knock on the door, and the friend is gone, and Cathy and I are sitting there working on our computer on our project. And they say, hey, can we come in and search the house? We're like, yeah, okay. They're not going to say, are you on the title? Do you live here? They're going to search the house. We're going to give them consent to do that. Now, the defense attorney for our friend will say, well, you know what? They were just temporary visitors. They didn't have the lawful consent, and they don't have the ability to consent. So that will be litigated. It'll be a tough call. The easier call, however, Janine, is let's say Martha and John live in a house.
Let me stop you there. Well, what was the court case? And wasn't it between a husband and a wife?
Yep, it was between a husband and wife.
So tell us about just that case. What did the husband say?
Well, I think, as I recall the facts, that the husband said that the wife did not have consent, the ability to give consent for entry into the home, because he was on the title and he was the lawful owner and she wasn't. And the court said it doesn't matter who's on the title. So
Okay.
the court has upheld consent in all sorts of different conditions. So for example, roommates, apartment mates, dorm mates, people who aren't related by blood. And so there are any number, courts have upheld kids, 18-year-old, 19-year-old college kids who are living at home for a period of time, giving consent for the police to come in and search.
Okay, well, let me back up and ask that. This is all really, really terrific information for everybody to know. When that police officer comes to the door and whomever opens the door and says, "Can I come in?" don't they have to have a warrant?
So that's the question, right? The answer is yes. However, the two exceptions are the exigent circumstances, which we just talked about, the kid in the burning house, or consent. And then the real question on the consent side is, like let's say you and your husband are sitting there in your house, and let's say, just for the sake of the argument, you are on the lease. I mean, you're on the title, you paid the whole thing off, and he just lives there. And the police come and knock on the door and say, "Hey, Fred, can I search the house?" If he says no, that's the end of it. If the person at the door who answers the door says no, that's the end of it, unless there's exigent circumstances. End of it meaning they have to go get a warrant. So you can say no. And when they say no, you don't hear about those cases because those cases aren't reported.
So if someone comes to your door, a police officer, and knocks on the door and says, "Can I come in?" Does the person whose consents have to at least be legal age? It can't be a 6-year-old,
Yes.
can it?
Right, that's correct. Yeah, so
Okay,
your toddler can't answer the door and say, "Sure, come see my mommy and daddy." That's
Okay.
Because they can't sign contracts either. They're not legally able to do a lot of things. They can't sign
okay.
contracts. They
So-
can't enter binding agreements.
They have to be of legal age,
Yeah.
so they can come in and say, "Yeah, come on in." But if they say, so a police officer can come into your house if consent is given without a warrant. If you don't give consent, they have to get a warrant. That's really interesting. I'm not sure I ever knew that. That's really, really interesting.
So if somebody knocks on Tova's house, on the front door of Tova's house, and Tova, you said you're 15 or 16?
16.
Yeah, 16. And the legal age of consent in that state is 18, which is usually the legal age of consent to sign contracts and be able to give valid consent for things. And she says, "Sure, my parents are terrific. You can come search the house." The cop should say, "Young lady, how old are you?" If he says later in court, "Well, I thought she was 18, that's probably not going to cut it. All right, even though she looks mature and is very mature, it's up to the police officer to make a reasonable inquiry into whether or not the person is able. I mean, if the person's 2 feet tall, wearing diapers, obviously the cop knows that they can't give consent. But if it's like Tova, who is a young lady, a young woman, the cop would probably be wise to say, "Ma'am, how old are you?" I'm 16. I'm sorry. Is anyone, is an adult in the house where I can get consent?
Okay, I need to pass this over to Tova and
Yep.
Cathy so they can ask. But I want to do a kind of a lightning round, couple of questions that are on my mind as if we're going commercial break here.
One
Okay.
thing it's important to keep in mind, Janine, is what is the remedy? The remedy is the hard part to wrap your head around. If there's a Fourth Amendment violation, in other words, there's a government action and they violate your Fourth Amendment right, that means that the government, the prosecutor, cannot use that evidence in their case in chief in a prosecution. They may be able to seize it for good, and that's a different topic for a different day, but they cannot use it in a trial against that individual. And what that oftentimes means, Janine, is that
if they entered illegally, they can't use it, right?
if it violates the person's Fourth Amendment rights.
Mm-hmm.
And the other thing is, Fourth Amendment rights are personal; they're not vicarious. So if Tova and I, if Cathy and I are sitting in a Starbucks having a coffee, and when I run to the bathroom, she looks on my phone. She doesn't have any permission to look at my phone, but she knew my password. She looks on my phone and finds something illegal on my phone, and then she turns me over to the cops, and the cops and the police and the prosecution prosecutes me for whatever's bad on my phone, it's illegal. I can't say she violated my rights, therefore you can't use the evidence because she's not a government actor. So Fourth Amendment rights are personal. So it's important to keep the remedy in mind.
Well, I think what you're saying there is actually somebody that's personal in your life can violate a friend, a family, sister or brother, because it's personal. If someone's personal in your life, they can violate it, but the government cannot violate it. The government just
Correct.
can't walk up and say, okay,
Correct.
real quick question, and I turn it over. Talk about the one thing I learned in all these studies that we've done is that what was fascinating about the way the Fourth Amendment is laid out is it doesn't say, we need to know if there's a bomb in this area, go search the entire street. I think that's what was happening in the olden days in Britain. And now they say they cannot. They have to be very specific about the house. And then they have to be specific about what they want inside the house. So last question from me is if there is a warrant, let's say they come to your house and say, we have a warrant to come in. Do they have to talk about how the warrant has to be super, super specific? And are they at that moment entitled to, do you have the right to hear from the police officer what the warrant is before they even come in? Like, this is a warrant, we're here to search for da 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 because of da 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 da, or they just say, we have a warrant, we're coming in?
So in practice, they're going to have, when they have a warrant, in theory, the warrant is going to be supported by probable cause, which it has to be. You saw that on the Fourth Amendment. And then the warrant is usually 10, 12, 15, 20 pages, and it's going to lay out specifically what they're able to search and what they're looking for. Now, it's not a debating society. And so they're not going to sit there and say, well, let's sit down and discuss the merits of our warrant.
No,
they're going to hand you the warrant. Right, they're going to hand you the
They tell
warrant, say, stand aside, and we're searching your house. And you really
So
don't have much say in it.
They don't tell you what, they just barge on in and say, read this as I'm looking around, or do they say, I'm here because of A, because of B?
Well, there's
At least it's
18,000, there's 750,000 different police officers in the country and 18,000 police departments. So I suspect practices vary.
But I mean, by law, they don't have to tell you what's in the warrant. They just say, we have a warrant, and they come in.
Well, they have to give you a copy of the warrant, and you can sit there and read it. And if they don't give you the copy of the warrant, I think that should be a red flag. But they don't have to sit there and debate the merits and the four corners of what's inside the warrant with you and let you nitpick
you would
it.
think you. So if someone comes to your door with a warrant and they hand it to you and you say, but tell me why you're here. I don't have time to read this. I'm too upset. Why are you here? They don't have to tell you. You just have to sit there and look through it while they're. That's fascinating.
Yeah, and I
okay,
recommend calling your attorney.
Yeah. Okay, Tova, go ahead, Tova.
Thank you so much. This has been really, really informative. I didn't know that it's just amazing how much there is to every single short sentence that the founders wrote so many years ago.
It really is, yeah.
Yeah, for sure. We've been getting a lot of audience questions, and personally, I have this question about how the Fourth Amendment impacts the lockdown restrictions or just the general government interventions with the coronavirus. Have there been any, I don't exactly know how it would apply, but have there been any lawsuits or concerns about the Fourth Amendment during this time?
So that's an outstanding question. I actually wrote a Wall Street Journal op-ed about state and federal government emergency powers with David Rivkin back in February. Remember that the states have police power, not the federal government, which I'm sure you've learned in your series here. And so it's up to the state governors to take care of the health and safety of its citizens. It's not up to the federal government to do that. The federal government's job with respect to our safety is for national defense and national security. And so honestly, the Fourth Amendment is not implicated or has been implicated in these COVID restrictions that these governors have passed. What has been implicated are First Amendment freedom of association and freedom of assembly rights. And so there have been lots of lawsuits, Tova, that have challenged, for example, one out of Nevada. How can the governor say, casinos can open up the spigot and let all sorts of people in it, and yet churches can only have a small number of people in the same state because the COVID bug doesn't discriminate between gamblers and churchgoers. The Pennsylvania governor was struck down recently by the Pennsylvania Supreme Court in a decision that I wrote about recently, and so was the Michigan governor, where the assertion of governmental power was overbroad. But the Fourth Amendment has not been implicated. Interesting question, though, Tova, and I don't know the answer to this because I haven't researched it, is would the Fifth Amendment right for just compensation for undue taking be implicated for COVID restrictions by treating people differently and essentially seizing their property without just compensation because of draconian COVID restrictions? I don't know, but not the Fourth Amendment, at least not yet, thank goodness.
Thank you. That's really interesting. That's an interesting thing you bring up with the Fifth Amendment. I'm curious to see how that plays out. And then I just have a few questions about more specific scenarios that might come up under this law or under this article. So we had Robert Zimmerman asked a question, which I thought was really good, talking about if the police come in, they have a warrant for one thing and they come in for one illegal activity, but they find evidence of a different illegal activity. Are they allowed to use that in court, or do they have to obtain another warrant?
So I know you have a really bright future and you might end up even being a lawyer. So you got to learn the answer. It depends. This depends completely on the facts. And so I don't have enough facts from Robert's hypo, but let me pretend to channel my inner Robert for a minute. Let's say on the one hand, they're looking for drug paraphernalia. And they specifically say, based on a confidential informant, that the drug paraphernalia is in the upper chest of drawers in his bedroom on the right side. And the police have the warrant. It's particular. It's not a general warrant. And they go into the bedroom. They, as they're walking over to that chest of drawers and they're pulling open the drawer, they see a machine gun sitting on top of the bureau, or they see a hostage wrapped up with a gag in her mouth over there going, help me, help me. Well, obviously they can seize the machine gun or they can help the poor hostage because it's in plain view, right? Remember the plain view doctrine. If, however, let's channel my inner Robert and say he's looking for drug paraphernalia in the upper right drawer and they decide to go down into the basement 3 floors below his bedroom, and they break open a storage unit which has a padlock on it, and they find, surface to air missiles or some, drugs. Well, no way. That's way outside the 4 corners of that particular warrant, and that would be litigated. And let's just say on those facts, pretty clear, the judge would throw it out. Now, what the government will argue is that, well, we would have inevitably discovered that anyway. And so therefore it should come in anyway. And that's a totally different line of cases. One thing I would say, Tova, and this is to you and all your colleagues out there, is I know it was great swag that Cathy was talking about that are in the auction. And I think I'm going to take a long look at that after this program. Another freebie is the Heritage Guide to the Constitution, which is online and it's free. And you can click on the various clauses and amendments to the Constitution and learn more about it yourself. And it's written by hundreds of scholars around the country. So it's a good freebie to give yourself. And of course, Randy Barnett's book, and you featured Randy a while ago, is also awesome to watch.
That's great. Thank you. And then I was also wondering, I know you mentioned that with a car, it has like less strict rights than a house because it's mobile.
Well, cars don't have rights, but people who are in cars have less rights than people in homes, right?
Right. So I was wondering, has that been applied to, for example, homeless people or people who live in RVs who just by nature of their situation are mobile? Is that considered to be under the jurisdiction of like being a home and therefore like having more rights applied to them? Or would it be considered, because it is mobile, like does that override the fact that it's their house or their home?
So there are thousands of cases out there in the lower federal courts and state courts on this, so I can't make a general rule, but I will say that if a person lives in a tent and it does not have a bricks and mortar home, but lives in a tent as their house, the rules applicable to houses apply compared to the rules that are applicable to cars that apply. If you're living in the outside with no tent, then obviously advocates who do pro bono work for homeless people will advocate that even their small space, including their sleeping bag, is their domain, and that rule should apply. So it's a very fact-specific inquiry. I will say for students, the good news is you do have your Fourth Amendment rights when you're in high school. The bad news is they're diminished. And the Supreme Court in a series of cases has talked about how only reasonable suspicion is required for public school teachers to take action to look into your lockers and your backpacks and that sort of thing. If you go to a private school, forget about it because they're not state actors.
Wow, I feel like I should sue my teachers who opened my lockers to see how messy it was. That's not a right they have to know that.
Good luck with that one.
And then also, I was just one more, if I could ask quickly.
Sure.
Stop and frisk policies. I know
Yeah.
that's been like really controversial and has been tried a lot in court, but I think ultimately they were ruled constitutional. Like why were they considered constitutional? I know you said that there was a clause that if a police officer has reasonable suspicion based on their expertise, but like how would they know that if it's just a person walking down the street? Like how is this law interpreted?
So the way it's applied, Tova, and that's a great question, is it's applied on a case-by-case basis, and the cop has to make out a very specific set of facts and lay out based on her training and experience, what her training and experience is, what she saw, and what she did as a result of seeing it, and why it was significant to her. So for example, let's say she got out of the academy yesterday. In other words, she has zero experience. And she's walking down the street and she sees a guy with baggy pants and his hands shoved in his pockets. And she's like, And she walks up and pats him down. That's not going to pass the smell test. Doesn't pass the smell test to you, right? You don't have a law degree yet. It just doesn't pass the smell test. And so it's a very fact-specific inquiry. And she's going to have to lay out her training and experience and why, in her judgment, the furtive or other actions that the person takes rise to the level of a reasonable suspicion. There is a little twist on that, and there is the plain field doctrine too. So we talked about Terry stops and pat search. The court has also upheld in a case called Minnesota against Dickerson, when a cop is patting somebody down, if they pat somebody down and they feel what they believe to be a weapon or drug paraphernalia, which is packaged in specific ways in various different cities, they can seize that without a warrant. The guns for officer safety purposes, the drugs, because the court has upheld that. So that's called the plain field doctrine, and they've allowed for that. I get your point that the stop and frisk is a controversial policy in some places, but as a constitutional matter, it's certainly allowed.
Well, thank you. This has been fascinating. Tova, do you have any other questions? Because I want to make sure we get to some audience questions as well. And we've got one from Riley Meckley in the 11th grade. And Riley writes, did the delegates from the northern states have disagreements with the delegates from the southern states in regards to who can be searched, especially pertaining to slaves and women at the time in 1787? So I think the question is, did the Fourth Amendment, when they wrote it, apply to everyone, or was it, how did women and slaves work into that?
Well, I don't know the answer to that in terms of being able to point to cases, but I can tell you that, as I mentioned, that remember, the Fourth Amendment only applied to the federal government for the longest period of time, and there was not a large federal police force, and it didn't apply to the states. And so it was not being used that much to exclude evidence, because remember, back then, the remedy was unclear as to whether you would exclude the evidence or not even. And so obviously the Dred Scott decision, which I'm sure you've all heard about, is an abominable decision, and slaves were treated in a subhuman manner, legally and otherwise. And women, of course, didn't have the right to vote till much later. But I'm not sure I know the answer to that. It'd be a good thing to research, because I just don't know the answer.
Right. That's a definite good research topic for Riley then.
Yep.
Michael Amowitz asks, if police have a warrant and want to enter, where do you look on the warrant for what they're searching for?
That's a great question. It should be within the four corners of the document in plain English or whatever language that the occupant typically speaks. So if they're Spanish, it should be in Spanish. A lot of jurisdictions will use warrants in various languages that allow the person to be able to read and understand it. There's some case law out there also, Michael, that says that you should be able to read, you're required to read the warrant for certain people who are unable to read. And there's certainly people in our society who are unable to read. And so that would be litigated as well. But it should be and is required to be by the Fourth Amendment in the document itself. In the warrant, I've been privy to writing or seeing or signing, I don't know how many warrants, lots of warrants in my 30 years of practice. And typically it's right on the first page, right on the front and center. And if it's not well written.
And then Michael also asked, are there circumstances in which a warrant can be issued to search for nothing in particular? Or do they have to say they're searching for something? I mean,
they have to say they're searching for something because remember, let's go back to first principles. The language of the Fourth Amendment says that no warrant shall issue but upon probable cause supported by oath or affirmation and particularly describing the place to be searched and the persons or things to be seized. So the problem, Michael, is what you're describing is a general warrant, the very thing the colonists rejected. And the folks who got together in 1791 to pass the first Bill of Rights, which were the first 10 amendments, specifically were recoiling against.
Tova, did you have a question?
Oh yeah, sorry. I just was wondering, you were mentioning that they have to make the warrant readable. And does that apply to people who, need a sign language interpreter? What if they show up and they realize the person is deaf? Do they have to stop and get an interpreter? Or what if the person is, has a disability and is autistic, for example? Do they have to break it down into language they can understand? Is there any guarantee that the person has to understand it or just that you have to hand something to them?
Well, I grant you junior lawyer status now because that's exactly the type of thing that's litigated in courts every single day. I mean, what is the disability or disqualification or barrier that allowed the person not to understand that the warrant was there? The fact is that most cases most judges will say, look, the warrant was served on the person in the house. They did their best to communicate what it was about. The officer showing up with their badge, the person could at least understand to call their lawyer. Because remember what I said is, because remember Janine asked the question, do you have to have a debate about what's in the warrant or you just sort of grin and bear it, hand them the warrant and then do the search? It's not a debating time. It's not a time for a church chat. It's just a time to serve the warrant and then do the search. Now, if I was a defense attorney, and I have been many times, I would litigate that potentially, depending on the facts and circumstances. You did mention autistic. There are people who have diminished capacity. That's a legal term, not trying to make a psychological or prudential judgment, but diminished legal capacity to engage in the legal process and accept service of process. In other words, a service of warrant. And that's a different line of cases, but we're not talking about that here.
Well, and we're getting close to the time that we have to wrap, but I do have one last question. I remember a couple of really high profile criminal cases in the past that I'm wondering if the Fourth Amendment was used or how, or maybe if it even slowed down solving those cases. One comes to mind, the DC sniper, when there was a rumor that it was a windowless white van. And I remember driving around DC, seeing all these windowless white vans and, wondering myself, could that be the sniper? And
Sure.
Could police just randomly search windowless white vans in a situation like that? Or in the Boston Marathon bombing, where I think they had pinpointed the suspects to a certain neighborhood, and did they go house to house searching for the suspects? Do you remember either of those cases? And how
I not only remember I've written about the Tsarnaev brothers in the Boston bombing, and of course I lived through the DC sniper problem. Another case comes to mind that we talked about before the show, Cathy, and that is the Golden State Killer. This was a horrible murderer guy who went around and murdered people for many, many years. He left DNA at all the crime scenes, but there was no match in all the government DNA databases. And the question in that case, when they finally solved it, is, did his relative, 20 cousins removed, who wanted to get her 23andMe DNA match? She wanted to find out more about her genealogy. She didn't know she was related to this guy. She pays for the service. She does her swab. She gets her little profile back, her DNA profile. She wants to find out more about her family tree. She uploads that to GED Match, which is a third-party consumer genetics public website, which gives you a huge family tree, 25 different strands in that tree. And the police, Cathy, take the crime scene DNA that they don't know who it belongs to, upload that DNA to GED Match, which is a public website, and it gives a match. It says, this person's DNA is related to these 12,000 people. And the police, through regular old police work, eliminate most of them, because most of them are dead, right? And they narrow it down to 2 or 3 people who are living who might match the suspect. And sure enough, they found this guy, and they saw him in a bar. He was drinking out of a soda can or something. He takes a sip. He throws the can away. They get the can. They test the can, and boom, his DNA matches the DNA left in the crime scenes. And that's found to be not violation of the Fourth Amendment. Why? Because Fourth Amendment rights are not vicarious. So the lady way over here on this side of the family tree, who voluntarily posted her DNA family information in exchange for the information she wanted to, whet her appetite about her family, she did not violate his Fourth Amendment rights, because she can't. She's not a government actor. And so in the DC sniper case, and the Tsarnaev brothers, the Boston bombers, the police had exigent circumstances which allowed them to go from house to house. Remember, the helicopter was at night with the spotlights, and the one Tsarnaev brother was in the boat, under the cover of the boat, and they had the thermal image of the guy in the boat. They knew he was alive because he was moving, and it was not a violation of any one's Fourth Amendment rights when the police were jumping through their fences, et cetera. And by the way, they're not being prosecuted, so they don't have any Fourth Amendment rights to be violated. Now, they may have had property destroyed, and the city may reimburse them for the fence the police cut or broke when they jumped over it. But the only person with the Fourth Amendment rights is Dzhokhar Tsarnaev, who was the guy who lived. The other guy got killed in a shootout.
Wow, that is fascinating. And I'm so glad that you brought up the case on the genetic testing, because that is something that I had been curious about also. Well, we could obviously spend several more hours talking about this, talking about the Fourth Amendment. We just thank you so much for your time. You were just a wealth of knowledge, and I think we all learned so much. So thank you for being with us today.
It was a real pleasure. Thank you very much, Cathy, and everybody.